Welcome to the Explainer. For a minute, let's forget about Washington because the real action in AI regulation, it's happening on the coasts. Today, we are digging into New York's new RAISE Act. That stands for the Responsible AI Safety and Education Act, and how it's basically teaming up with California to build one powerful national rulebook for artificial intelligence. Right. So while the federal government is still debating, what we're seeing is this powerful de facto national standard for AI being built from the outside in. By syncing up their laws, New York and California are creating a single, high-stakes set of rules that, let's be honest, the biggest names in tech just can't afford to ignore. So here's what we're going to cover. We'll look at what this new standard really is, who it's going to affect, and what the new rulebook actually says. Then we'll get into the penalties, because they're serious. And finally, what all of this means for the future of AI. Okay, first up, how did we even get here? Well, with this new law, New York has officially jumped in the ring with California, right at the forefront of regulating the most powerful AI, and that creates a whole new dynamic in the world of tech law. So on December 19th, 2025, Governor Kathy Hochul signed the RAISE Act. Its focus is really laser-sharp, safety and transparency, specifically for the developers of these massive AI models. And since it's designed to mirror California's law so closely, it creates what one source is calling a bi-coastal pillar for regulation. Now, the timeline here is actually pretty fascinating. California's law kicks in a full year before New York's. And what that does is it gives developers a running start to figure out compliance on the West Coast before the East Coast rules go live. It's essentially a phased, nationwide rollout, almost by design. All right, so who exactly do these new rules apply to? Let's get into the definitions because the devil is absolutely in the details here. So the RAISE Act originally defines a large developer, not by its headcount or its profits, but by how much cash it's spending on pure computational power. And these thresholds are pretty steep. We're talking over $5 million on a single model and more than $100 million in total compute costs. The law goes after what it calls frontier models. Now, these are defined by their just mind-boggling size. That's 10 to the 26th power operations, or by a really specific training method called knowledge distillation. You can think of it like a genius professor teaching a student, passing down its smarts. It's a pretty wild technical detail to see actually written into law. And this slide really shows you how they're pushing for alignment. See, at first, New York used compute cost to define a developer, while California used annual revenue. But, and this is part of the deal to get the bill passed, New York lawmakers have already agreed they're going to change their law to match California's. It's all about smoothing out the kinks to create that single rulebook. Okay, so what is actually in this new rulebook? Well, developers now have a whole new checklist of legal obligations they have to meet. So before they can even deploy one of these frontier models, developers have to create, publish, and stick to a really detailed safety and security protocol. And look, this is not just some fluffy mission statement. It's a full-blown document covering all 6 of these areas, right down to naming the senior-level person whose job is on the line if things go wrong. The whole point of this protocol is to prevent what the law calls critical harm, and the definition they use is incredibly specific. We are talking about an event that causes the death or serious injury of more than 100 people, or at least $1 billion in damage. The stakes are, well, they're huge. So that's the number to remember. Regulators have put a very clear, very sobering figure on what they see as a catastrophe in this new age of AI. 100 or more people. That's the human cost, the threshold that kicks all these rules into high gear. But this is where it gets a little nuanced. Even though the laws are aligning, they're not perfect copies. You can see here that California's threshold for harm is actually lower, 50 people instead of New York's 100. They also define things a bit differently, like which crimes are covered, or what happens if a model goes rogue. These are the kinds of details that will have to be ironed out eventually. And the differences don't stop there. New York is making companies get a full, independent, third-party audit every single year. And this is the key part. That entire report has to be made public. I mean, that is a huge leap for transparency, and it goes way beyond California's rule, which just asks developers to say if they got outside help. And if something does go wrong, say a security breach, or a model starts doing things it shouldn't, developers have to report it, and they have to do it fast. New York gives them just 72 hours. That is a way tighter deadline than California's 15 days for most incidents, and it puts enormous pressure on these companies to be ready. Right, so what happens if you don't follow the rules? Well, the state is not playing around here. The penalties are significant. For a first offense, the New York Attorney General can hit a company with a civil penalty of up to $1 million. That's a serious chunk of change that's meant to make sure this isn't just a paper-pushing exercise. And for any violation after that, the potential fine triples to $3 million. This whole escalating system is designed to punish repeat offenders hard and really show that the state means business. The law also sets up a brand new oversight office, which is funded by the developers themselves, and it gives the courts two really powerful tools. First, they can pierce the corporate veil, which basically means they can go after the actual people in charge, not just some shell company. And second, they can just void any contract that tries to pass the buck for a violation onto someone else. Okay, let's zoom out for a second and look at the big picture here. What are the major takeaways from all this? Well, the most crucial point, and this is something legal experts at DLA Piper have noted, is that we're literally watching a national standard being born. And it's not being driven by Washington, it's being driven by the states. What happens in New York and California is going to send ripples across the entire country. And it's so important to get this part. This new standard is all about pulling back the curtain. It's about forcing transparency and reporting on safety, not about telling developers how they should build their models. But you have to imagine all this new public information could easily spark future debates about even tougher rules down the line. So this all leaves us with one massive question for the future of AI in America, right? Is Washington going to look at this bicoastal blueprint and say, yep, that's the one, and adopt it? Or are we going to see a competing federal plan, which could create a really complicated and messy patchwork of rules for one of the most important technologies of our time?